Anthea, I suppose let's just give our listeners a refresh on where we are in the process, and I think if you can tell us a bit about what concerns us about Motsega's comments in general, that might also be helpful.
Right. In December last year, just as the festive season began, the ad hoc committee for the drafting of legislation to amend the Constitution to allow EWC gazetted a bill. It's called the Draft Constitution Amendment, 18th Amendment Bill. Comments on it are due by the end of this month. And what it basically says is that the courts will have the option to decide that nil compensation should be paid, not only for land but also for the improvements on it. And in addition, that Parliament will have the power to adopt subsequent legislation by ordinary 51% majority, saying when nil compensation can be ordered by the courts. Now, this is worrying enough in itself, but at least it does give the power to decide on nil compensation to the judiciary. Now the ANC's idea, as reflected at the recent Lekgotla and incorporated in a statement by President Ramaphosa thereafter, is that the decisions on compensation should be made by the executive and not by the courts. So in other words, if your property, your home, which is the improvement on your piece of land that you own, is going to be expropriated, say by the housing department because it says it wants social housing, much more dense housing in that area, then the minister would be able to decide not only that the property should be expropriated, but also that you should get nil compensation for it. And that's an extraordinary thing because it goes right against the separation of powers and the idea that the courts must act as a check on the executive. And it will be much more difficult for individuals to contest that. If the courts have the power to adjudicate, to make their own rulings on what compensation will be, they will look at all the factors which they consider important. If all that they can do is review a decision that's been made by the executive, then the grounds for review are much more limited. In essence, whether the decision is so unreasonable that no proper decision maker could have made it. So there will still be some role for the courts, but they'll only be able to review on these limited grounds set out in the Promotion of Administrative Justice Act, and they won't ever be able to substitute their own view on what compensation should be. So if they strike the executive's decision down, well, then the executive will come with a new decision. And if you don't like that, then you must go back to court for another review. And again, the courts can at most say, no, we don't approve, but we can't decide. So it becomes a much longer and more costly process, which means that if you want to try and contest being offered nil or a very small amount of compensation, you have a much more difficult path before you and a much more costly one.
And if I can follow that question up with, so there's this new, more radical idea, the idea being put forward at the Lekgotla, but the idea that we currently have gazetted is also got problems. One of them is the idea that if I understand correctly, your property can be expropriated without compensation. And then afterwards you have to go to appeal, and the burden of proof is almost on you, and certainly the costs for the legal action are going to fall on you. And at a time when you've just had your property taken out. If it's your home, that's going to be a very important thing. And if it's your business, that's going to wipe out your ability to earn you money. So that makes it difficult as well. So tell me if I've got that wrong. And then it seems to me, has the government put forward a formula for how to think about what the compensation value should be in the first place? I feel like you've written about that before.
Well, what we're seeing is a gradual ratcheting up of the pressure, because we already know from the Expropriation Bill of 2019 that was gazetted at the end of 2018 that the whole process for expropriation is very much skewed in favor of the state. That having taken certain preliminary steps like investigating your property and seeing whether they think it's suitable, they can issue a notice of expropriation. And that notice will specify the date on which ownership will pass automatically by operation of law to the government. And that date could be very soon. It could be within a week of your getting the notice of expropriation. They'll also say when the right to possess the property will pass automatically to the state. And that could be within another week or a few days. And though under the existing expropriation bill, you'd have the right to go to court for a different ruling on what the compensation should be for most people, reeling from the loss of the right to own and possess their properties, it's not a very real option. But it will become even less real if the courts can't make a ruling on what compensation should be. They can only say, we disagree with the amount that you've been offered by the executive, but we can't substitute our own view. If you're not happy with the new amount that's given by the executive, well, then you must come back to us again. It just makes it such an enormous burden that for most ordinary people, it's not feasible at all to try and invoke what will remain as the court's power to review. And it will mean that the executive will effectively be able to decide on zero compensation in almost any circumstances, because we don't have clear parameters on when that will apply.